their entitlement to be legislators is not taken away.
Because
You are entitled to say, I don't form a part of the merger. I stay back and I continue with my own.
I'm very grateful, Manus. I'm very grateful. Because, Manus, and quite right, it is not their fault. The remaining 10 can't be disqualified because 75 have gone with it. So that's a very logical. Now just continue the suffix. Suffix is important. And from the time of such merger, continues, such other political party or new political party or group as the case may be shall be deemed to be the political party to which he belongs for the purposes of sojourn. Now,
Deeming occurs subsequent. The deeming doesn't occur prior.
That's one of the important points of time. Absolutely right. So, Malas, merger is the only difference.
Yes.
Now, and may I state the fourth one and then I'll make my submission. The fourth element is the election commission in some form will be deciding a majority. I'm using the word largely and loosely. Majority. My question to myself is, how does the election commission maintain a complaint by people who are not recognized under the defection law as a merged party? Number one.
Just a moment.
How do they enter the door of the election commission? Look at the irony here. This is very interesting political irony here, which I'll come to in a minute. You can't maintain my complaint because you asked me at the door, who are you? How have you come here? Second, the election commission will decide majority by persons who, if the proceed, will be disqualified tomorrow. Well, can your lordship form any part of a majority if somebody is disqualified? But deciding this bunch of people is disqualified or not. They will be the same people who will be the majority considered by the EC and will be subsequently held to be disqualified. Well, it is putting the cart before the horse. I don't understand why a constitution bench can't decide the basic issue and the election commission can wait. What is the value? What is the urgency? What is the balance of convenience? It is to make it irreversible. It is to make it a fait accompli. It is to then come and say, oh, there is the constitutional authority which has decided. Now what is left? That is the real purpose.
All right. Yes, you got your 4 points. Now, you go to the next point.
Just note for one thing. Well, if you are, what happens? Well, there is a dilemma which is there. You have left the Shiv Sena, but you want to have the goodwill of the Shiv Sena, so you don't merge. And you merge and knock at the doors, you'll be a new political party, subject to numbers. You want the best of both the worlds. You are admittedly claiming that you are the Shiv Sena, which is a concept not recognized in the 10th schedule. Where is it recognized? Anywhere. And you want to yet call us a Shiv Sena and yet say that no, you can go. Well, in what form? This is driving the coach and four through this. And Wallace's fifth point is, this thing was enacted, Wallace, 15 years, 20 years after, on the Gayaram scourge, with a huge amount of discussion, and amended in 2003. We are talking of largely a procedural construct of a symbols order, how the election commission will proceed.
Dr. Singhvi, you're right. Dr. Singhvi, you're right that the 10th schedule does not recognize who is the real party. Party A, you are the Shiv Sena.
Yes.
But is that a concept which is alien to the symbols order? No.
Well,
the symbols order, who represents or who is the real party,
yes,
is not alien to the symbols order. You're right, because the 10th schedule is extremely tightly structured. The only defense is that of a merger. There is now no defense of a faction, of a split, of a one-third split. Yes.
One answer is that, assuming it is so, I'm not conceding that. I'm just answering my lot of two alternative points. That has to logically follow, not precede.
See, let me tell you, what is really troubling is this.
Yes, yes.
The whole concept of disqualification is in relation to the House.
Yes.
All right? The jurisdiction of the Election Commission is to decide who represents the political party. right? Which of various factions represent the political party. The Election Commission exercises superintendence and control over the elections under 324, Article 324. What happens on the floor of the House is a microcosm of the consequence of the holding of an election. Right? That, so that is an area where, there is a little bit of constitutional thought to be done.
The Election Commission has to look at the legislative and the non-legislative wings of the party, decided by your lordships repeatedly, including the famous case of Saranja. That's answer number one. Your lordship should not be under the impression.
So your contention is that therefore, your contention really is that because the legislative wing of the party is brought under a cloud by virtue of the disqualification proceedings, therefore the Election Commission is necessarily then to be stultified or to be interdicted from exercising its jurisdiction in regard to the non-legislative part of the party. That's an area which is a little bit of.
Well, I were educated to appear in the Election Commission symbol of the cases. What they
in our compiling.
I just give one.
There are 3 or 4 answers. Just kindly take this common convenience compilation. This will solve a lot of problems. There is this volume I have taken out of this. Your lordships had them taken out. It's called common convenience volume. Just 2 or 3 pages. There
Old one.
Common convenience volume. Old one.
क्या मेन पेपर बुक में है सर?
two or three things here.
What are you showing, Dr. Singh?
Yes. First,
So we don't get identical. What exactly are you showing?
I am showing, Willis, in that volume, common compilation volume, the Election Commission notice at 698, page number. 1 minute. Yes, sir.
What is the date of that?
Election Commission is dated
Page 1853.
22nd July
1853. 22nd
July 2022.
Dr. Singhvi, why don't you give us a PDF page?
That was meant for the main hearing, not for today. I should take a technical objection, so still that. Our training is still incomplete. That 22nd July.
Now, 1853. Incidentally, for the record, it is page 1853 of the PDF pages.
185. Yeah, great.
Dr. Singhvi, at 12 sharp, we'll wrap up with your side. We'll give you another 5 minutes, and
Yes,
so that
I'll be very.
we'll just take a short break, a comfort break, and we'll return to hear the arguments of the respondents after.
So, let me be very pointed. Now, this page, which your Lordship has got the PDF of, the notice itself, as in all election matters, the symbol matters of the Election Commission. See the last page, 702. I'm sorry, I'm not able to assist. 3 pages later. The last but one paragraph.
1857.
Yes. Require, well, let's just see the top paragraph. Prior to the hearing of the two rival groups, if any, inter alia require both rival groups to submit their respective documentary evidence of support claimed by them in the organizational and legislative wings of the party. That phrase I'm asking Lordship to underline. Now, let's very quickly, if your Lordship doesn't mind, going back to my page 684, which should be, well, about 10 pages out here. PDF page, no PDF. My learned opponents, well, filing in the EC is very revealing. What they file. That starts at my page 670.
Interestingly, both sides in their written submissions have referred to the pleadings of the other. What the other side, when you filed your pleadings, both of you didn't have an idea of this thing that is going to now happen here.
I have said anything very seriously wrong, but this is very interesting what they have said. And this is 684.
684.
Yes. It's para 23, small Roman 23. Yeah. It is submitted that the petitioner, now this is the petitioner, the other side, presently enjoys the support of 40 out of 55 MLAs of the Shiva Sena. This is directly another issue. There is no question of 40 out of 55 disqualified people. In the Maharashtra Assembly, a resolution dated 26th of June passed by 40 MLAs reaffirming their support and faith in the petitioner and the main leader to the next. That's point.
But can the EC proceed on a demurrer that assuming that these 40 persons are not to be taken into account in determining who represents, which faction represents the Sena,
Then the petition
even so?
That petition can't be filed. So there's no such thing. The petition can't be filed because the approach is all details of organizational and legislative, and just these 2 pages later, 687.
687.
2 pages. Well, the filer, the approacher is Mr. Shinde. He's not a member of the Legislative Assembly. Is he not claiming on the basis of the Legislative Assembly status?
Right. Page 687.
Now, 687, on the top 4th line, organizational and legislative wings of the party. 4th line, para 9, on the top of the page. Then para 10, next para, 4th line, all layers of organization as well as legislation wings. I can multiply this now, my time is short, so please come to Sadiq Ali. The citation is 1972, volume 4 SCC, 1972, volume 4 SCC, 664. What document Lord is
now I
reading,
think that is the
what document my Lord is reading has been filed by a sole person, Mr. Eknath Shinde, whose only
Right.
status is that of a supposed MLA of the Shiv Sena, is what I will say. Now,
are you now reading Sadiq Ali?
Sadiq Ali, para
I think Sadiq Ali is part of the convenience
yes,
compilation.
page 14 of their convenience compilation, the other side, but your Lordship can get it in so many forms.
Just give us a moment.
Para 26 there is. As your Lordship knows, this judgment has stood the test of time, even though it is
Election
predating
Yeah, it is so.
I'm great.
Yes, Dr. Singh, we've
That's all.
got
I'm
it.
not concerned about the final merits.
Very
Your Lordship is told that it's what I'm objecting. As if there are two unrelated issues. Now, just see, brothers, in their complaint, in Mr. Shinde's status, in their pleadings, they say, I have so many MLAs of organization of the two houses of parliament and of the state legislatures, as well as those of AICC members and delegates who supported Congress J, have not been shown to us to be incorrect. It is in view of those figures, it can hardly be disputed that substantial majority of the members of the Congress in both its legislative wing as well as organizational wing supported by Congress J. That's why the same phrase is used in the notice of the Election Commission. Same phrase. As Congress is a democratic organization, the test of majority and numerical strength, in our opinion, is very valuable and relevant test. Then, well, they go on. Well, this is, of course, 68 is 15 years prior or 20 years prior to state schedule. Judgment is prior, but I'm at the moment on the judgment's own terms. Well, can you separate? Can you, you are told, that this is unrelated issue. Then, also note para 29, the last 4 lines. Majority of houses of parliament and sum total of members of state legislature. Last 2 lines of para 29 to save time. Last 2 lines of para 29. In any case. Last 2 lines of 29.
In any case.
3 lines. Now, this third aspect. Symbols order, which is very important to repeat, predates by 15, 20 years, 17 years, is premised upon not a disqualification situation. It is premised upon a dispute. Brothers, we are one group, we have a fight. He says, I want the symbol, I say, I want the symbol. It never contemplated the penal consequence of him being disqualified or being disqualified. It did not even enter their mind. Therefore, this was premised on the legislative wing. The logically prior stage has to be the disqualification. That is logically prior. Number 4, brothers, your Lordship uses this phrase, it has become a commonplace, but it is a lot of weight. Not when the Supreme Court uses it alone, even lower courts. What is the meaning of the subject to outcome? We just say it like that. Your Lordship will find the wire, yes, your Lordship says that. The idea is, look, I'm putting you on warning. You will claim equities because I may ultimately hold this way or that way. Now, this is the hiatus between them is several months.
All right, Dr. Singh, time. Can we wrap up on this?
Yes, I'm done with this. Because I want to only say one thing, that your Lordship will keep in mind also this concept of voluntarily gives up. Voluntarily gives up is a very important phrase, which your Lordship finds in 2.1a, inter alia. How do you voluntarily give up? You voluntarily give up when you don't satisfy the conditions of the state schedule. Suppose I expel you. Then, of course, you are not voluntarily giving. That's why I said, in the actual reality of political life, expulsion is welcome sometimes. It is a welcome. But, if you do some activity which is subject to disqualification and you leave and you proclaim yourself as a separate group, but don't merge. You have voluntarily given up membership. Because if you have given up membership, with greatest respect, how does para 15 apply? That too by the sole applicant before the election commission, Mr. Eknath Shinde. Who's the sole applicant? There is no other application. Today, Manas, your lordships can always decide, but today, Manas, he is under a cloud, under the simple text of 218.
All right, Dr. Sindhi, thank you very much. We'll just take a short break and we'll be back and we'll hear these. Yeah.
Balance of convenience of lordship doesn't have the impression that your lordship has some imminence or urgency.
Mr. Sibal made the point. We saw the of those orders. We can just see those for a moment. That's all that we'll share.
That's a different matter. The question is, it exists, is what I'm saying.
All right.
We direct, there are three enough. We direct the parties.
All right.